Today was the second day when the Supreme Court was listening to submissions from the CAK and the government of Kenya, as well as two foreign frequency carriers, regarding challenging an award by the court that gave local media owners a chance to own digital licenses. Now, yesterday was the CCK's turn to present the submissions, and today we had the media owners, and Patrick Amimo has been covering that for us from the Supreme Court. Patrick, what happened today?
Thank you so much, Tunya. Indeed, at the Supreme Court, day 2 of the digital migration case, and we had the State Law Office arguing its case, where the Attorney General is seeking to reverse the Court of Appeal orders that sought to give the three media houses, that's the Standard Media Group, the National Media Group, and Royal Media Services, digital frequencies. The Attorney General argues that these orders by the Court of Appeal were infringing or usurping the role of the Communication Authority of Kenya. The AG also took issue with the orders that nullified these other pay TV stations like StarTimes, Pan Africa Broadcasting to air content from the three media houses. The AG argues that this action was like also infringing on the rights of it was on the interests of these other players in this particular media industry. So the AG also took issue with the Court of Appeal's decision to extend the deadline to migrate digitally to September 30th. This says the lawyer who was representing the AG's office, Mr. Mwangi Njoroge, argued that the actions by the Court of Appeal were they overreached their mandate, because this issue, the extension of the digital migration deadline, it is a matter that is a preserve of the Communication Authority of Kenya. The lawyer for the Signet company also came to argue his case and said that the company did not infringe on the intellectual rights as had been argued by the three media houses, the three local media houses. He says these media houses they were not blocked from airing their content. Their content was still available. So the lawyer claims that Signet, by virtue of airing the content from free-to-air content from the local media houses without their right, the company had not infringed on their intellectual property rights. And the third lawyer we had was from the Pan Africa Media Services, who argued that the decision by the Court of Appeal to take away their distribution licenses from to nullify them, to restrict them from broadcasting frequencies, local content from the three media houses, that's the Standard Media Group, the National Media Group, and Royal Media Services. He argued that by them being denied that opportunity to broadcast this content, it was also injurious to them as a distributor, and he argued that these orders had overreached, the Court of Appeal had overreached their jurisdiction, and he was seeking that the Supreme Court should overturn this decision. The lawyer also argues that the lawyers who appeared this morning argued that the three media houses, the three local media houses did not present any evidence to show that they had spent over 40 billion shillings in infrastructure to lay the infrastructure, and that's why if we switch digital, they will be disadvantaged if they are not given the digital frequency. So those are the arguments that have been presented this morning, and we expect an afternoon session to continue later in the day, because at this time they've gone for lunch. From me at the Supreme Court, I'm Patrick Amimo. Back to the studio.
That's right, and that was Patrick Amimo coming to us live from the Supreme Court, where basically the government, the CAK, and the two foreign media owners are challenging an award that was given to the Media Owners Association of Kenya, giving them a right to actually own distribution licenses. Tomorrow is the third day of that particular hearing, then we'll wait for the Supreme Court ruling.